Hello, and welcome to today's webinar, Anatomy of a Lawsuit, What to Know About ERISA Class Action Litigation, presented by our sponsor, Heffernan. We're so happy you can join us. My name is Amanda Ramatar, and I will be your moderator today, and I will also be monitoring questions you may have during this session. Before we open up this session, let's review a couple of key items. All of the webinar materials we discuss can be found at the URL currently showing on your screen. I will be sharing this URL in a follow-up email, so don't feel like you need to write it down right now. If you have trouble with your internet connection during the webinar, we recommend leaving the presentation and logging back in. We do not control the audio. Your devices control the audio. So if you have audio difficulties, try adjusting the volume settings on your device. If a telephone line goes dead during the call, hang up and call back again to the same number. If all the lines go dead, watch the on-screen chat box for an alternative call-in number. Feel free to ask questions or provide feedback by using the chat box or questions box during the webinar. If you're using a tablet, you may need to tap on the screen for the options bar to appear, then you can select the appropriate option. We may not respond immediately, but we will work your questions or feedback into the presentation. If we can't get to your comment or question during the session, we will be online afterwards to respond, or we may follow up in an email if we run completely out of time. You may also email us at moderator@aspenrmg.com for up to 48 hours after the webinar. This will be a 1-hour presentation. Questions and comments are very much encouraged throughout, and the presenters will be answering questions throughout the presentation. And lastly, we have a number of upcoming webinars covering a variety of topics, including those listed at the Heffernan webinar website. In addition, we are offering the mandatory preventing harassment training in English on June 20th this year. With that, let's begin today's webinar, Anatomy of a Lawsuit, What to Know About ERISA Class Action Litigation. Our presenters today are Jen Squillario, Eric Paley, and John Clark. Jen Squillario is a seasoned litigator and a partner at Nixon Peabody. She represents companies, executives, and fiduciaries in connection with the Employee Retirement Income Security Act litigation, employee benefits, and executive compensation matters, class actions, and other commercial disputes. Jen also has significant experience in complex disputes involving financial products and managing e-discovery in large internal and governmental investigations and heavy document litigation. Eric Paley leads Nixon Peabody's employee benefits and executive compensation team. Eric focuses his practice on the law and regulations governing retirement plans, non-qualified deferred compensation plans, and equity compensation plans. A significant portion of Eric's practice also involves counseling retirement and welfare plan committees on their fiduciary responsibilities under the Employee Retirement Income Security Act. Eric represents both publicly traded and privately held businesses in a variety of benefits matters. He also represents a large number of not-for-profit clients, such as multi-hospital health systems, colleges or universities, and internationally recognized arts organizations and museums. John Clark has been a member of Heffernan's retirement team for 15 years and has over 20 years of industry experience, both on the advisor and on the record keeper side. He's responsible for helping his clients fulfill their fiduciary obligations, but is also working to help educate their employees about the benefits of the retirement plan. He has also obtained the CFPR designation. Thank you for being with us today, Jen, Eric, and John. I'm going to turn the controls over. One moment, please.
That's great. And let's see if I can ably do this. All right. Thank you, Amanda. Welcome, everybody. Before I turn this over to John, I just wanted to frame the discussion. Super excited to participate here today and really turn this over to my friend and partner, Jen Squillario. Her bio doesn't do her justice. Jen is a seasoned ERISA litigator, absolutely, but for purposes of this discussion in particular, she's been, one of the attorneys at the forefront of this litigation representing companies over the last, what is it now, Jen, 18 years. And, some of these, some of the most important cases that have been part of the fee litigation franchise that began with Schlichter-Bogart many years ago. So, from our perspective, I'll say this from my perspective as a as an attendee in many respects, just like all of you. It's a real treat, I think, to hear someone who's been in the trenches and really gets to see firsthand how these lawsuits are litigated and has litigated them herself. Because I spend a lot of my day-to-day time, as my bio indicated, advising committees on what they should and shouldn't be doing. But I think it's a real focus shift for everybody to actually hear how the sausage gets made, if you will. And so if you've been through general presentations before on fiduciary responsibility and your retirement plans, I think this is going to be more of a unique experience. Not to put too much pressure on you, Jen, but I hope we're all going to learn something here about how this gets done, and it may flip your assumptions about things get done. So would certainly encourage you to submit questions. We've certainly got a lot of things I know, John, to ask Jen about, but obviously to the extent we can in this format to make it more of an interactive discussion, we would certainly love that. So I'm going to handle the slides and advancing them, but John, I'm going to turn it over to you to moderate and move things along.
Wonderful. Nothing like having a conversation with the litigator to really make your Tuesday morning feel like it's a high pressure stakes game. But we do want to thank you all for joining us again. This is not an intent to rile anybody up or get anybody too concerned. It's more to let you know where the lay of the land is. And Jennifer's been, as Eric said, in the trenches, actually seeing how this all is playing out at the ground level. So as much as you would like to, we can have Amanda present any questions you have. Jennifer and Eric, we have them for the hour. So if it's just me asking questions, that's going to be one point of view asking questions. But if there are plan sponsors or other individuals on the call that would like to ask their questions of these two individuals, we have them, so please use Amanda for that question. I'll start it off kind of with the 101. We say there are no dumb questions, but this is the basic questions. Where do these lawsuits start? Where do these cases start, Amanda, and how does this process look at the ground level?
Yeah, so that was the best easy question to start with, and I really appreciate that. So first we have to find the plaintiff, right? That seems pretty straightforward. So the next question obviously is how do they find their plaintiffs? How does a class action attorney find their plaintiffs? And there's a few ways. First, which you might not think about, a newspaper ad. It's a good way to find someone in a certain locale who did a certain job at a certain corporation. And I do know that some of the big ERISA litigators, plaintiffs, such as Slichter, had actually used newspaper ads, so that's a possibility. Social media ads is probably the one you're most familiar with, and that's an example that we have up there that Slichter actually used that we were able to locate. So those are the ones that are just easy to target, and they're widely used. The one that I find most interesting, because I found by mistake, is that actually some websites have been put up. So if I just Googled a name of a company with ERISA litigation, I came up with a plaintiff's big advertisement on a website, and the website was devoted completely to finding these plaintiffs, which I thought was pretty interesting. Disgruntled employees, in my experience, this is more common than you might think. It's often these plaintiffs are either past or present employees whom either have sued the company before or seem like they're almost always threatening to sue. And I just think maybe, I don't know if it's because it's like a chicken and the egg problem, right? So are they responding to the ads, or are these plaintiffs actually searching for these lawyers, which is, these plaintiffs and lawyers, which is quite possible as well. And then I've also seen referrals. So let's say they sue you for something relating to their employment, not related to ERISA, then that lawyer may then refer that plaintiff to their friend down the street who does ERISA class action. So that's another possible way. Okay, lastly, I have savvy litigious employees. So these are actually people who join groups with each other. I know one that even incorporated themselves. And they quarterly meet and then review what's going on with their plan and their money. And so I'm not saying, they may never sue and they do have to find a, lawyer to take their case, but there are some people out there, some employees past and present, who are just very interested, in following these and probably follow these cases. I gave you kind of an extreme example, but a less extreme example is in the university setting. Say professors may have a group where they get together and they talk about benefits, and they've always done this, but they're a little bit more attuned to these cases because they're, so frequent in their mind. Yeah. Okay.
So
Yeah. Go ahead, John. Sorry.
So taking a step back for some of the groups that are on here, you'd mentioned that you've been doing this now for 18 years. Can you kind of lay out for us a little bit of what these cases, as we're looking at it, who are the players? We talked about the plaintiffs and the plaintiffs' lawyers and the basics of who's involved, who's the defendant here, and kind of, I think that helps kind of set the stage in terms of where we're going to go on this conversation. Because
so
as the non-attorney, I get to ask the non-attorney questions.
We'll break it down. So you've got your plan sponsor. Usually your fiduciary committee will be sued. Ordinarily, the members of the committee will also be sued. And then also possibly your board of directors will be sued as well. And then really, it works differently with different plaintiffs' attorneys, but ordinarily we can work to get out the individuals, right? We don't want individuals sued here. And basically what plaintiffs are looking for is a stipulation that if there is any wrongdoing, that the plan sponsor will be responsible for payment. So it's just kind of a way to get everyone's attention, I think. So the complaint comes in, and then you have to notify the board of directors, hey, you've been sued. And then often committees have high level players, right? Maybe your general counsel, maybe your head of HR. And so it's really, I think they do it really, it's just attention grabbing, like, look, hey, you've been sued. And so it gets everyone involved.
Yeah, I can imagine getting a sort of lawsuit on your fiduciary obligation to your retirement plan wakes up just about everybody at every level of company.
Correct. Yeah.
In terms of looking at this, obviously, Heffernan works with a number of companies. I imagine everybody on here is at least somehow involved, either as a fiduciary or part of the investment committee. In looking at it, are after they get this lawsuits, what does the next step look like this? It's obviously going to be an all hands on deck. But after either the plaintiffs have found their attorney or the attorney has found their plaintiffs, whichever order they decide to go in, what does it look like next? In terms of things that the committee members should be aware of, fiduciaries, in terms of where it goes after that. Hey, they found a target, the target's found an attorney, and they're starting the process. What does that look like?
Yeah,
what should committee members and fiduciaries be aware of?
Yeah, I mean, ordinarily, we would want to get you want to make sure all your plan documents, all your committee minutes and meetings and everything is together, so that you can easily provide it to your attorney. So like the package of documents, you're really going to be focused on that. And then also maybe some initial interviews, right? Like I would want to talk to the committee members. Let's see what's going on. Because we have to prepare a motion to dismiss, and though a motion to dismiss is not ordinarily a lot of facts or documents, you still want to know. I would want to know as a defense attorney what's going on. What does the lay of the land look like? And so that's usually what it looks like at the beginning. So it's not a lot of involvement really for the committee members until you get down the line into some deposition discovery. So it's not too much of an onus on them, other than the fact that what they've done is being questioned, right? All the work and hard work they've put in is being questioned, and that obviously is quite annoying.
Right. That makes sense. I mean, obviously committees are trying to do everything they can to be compliant and have a good plan for their employees, and still not necessarily going to be bulletproof from being sued. Are there a set of things that would tip an employer off, or a plan sponsor fiduciary off, that they're at imminent risk of being sued, or things that they could kind of be on the watch out for? Obviously, sounds like you could search Facebook for, like my company's name, fiduciary lawsuit. But what are, is there anything to kind of look at this? I mean, obviously everybody who has a plan is technically a target.
Mm-hmm. If you start getting 104B4 letters requesting plan information from one of these plaintiff's attorneys, when that does a class action, I'm not talking about like a single plaintiff type of situation, but like if Schlichter always sends you one of these, then you should be tipped off that something could be down the line. There also may be nothing down the line, but it is an initial, you should start thinking about it. They don't always follow through. They don't always sue everyone they send those letters to. So it's not a necessary thing like that you will get sued, but it's a possibility. And then if you respond to that letter and then they keep asking for more documents, then you should be, you should really realize that this is a distinct possibility. But it could also be 6 months to a year down the line. It's not something that necessarily happens very quickly.
Jen, would a letter like that be coming, you call it a 104B4, I don't know if a lot of people know what that is, but the letter would be coming from a law firm on behalf of a participant in the plan, or would it just be a general request from the attorney?
No, they'll have their plaintiff, so they have their plaintiff already. And then you'll know if it's a real thing by the name of the lawyer who's representing them.
Okay.
Amanda, do we have any questions from our attendees?
Yes, we had one come in. So they asked, how do the plaintiff lawyers find defendants?
Oh, I do. I don't know the secret sauce completely, but I have a little bit of understanding, particularly at the Schlichter law firm. There are attorneys whose sole job at these law firms is to read your Form 5500s and then anything that is publicly available about your plan on the internet. And then they put together, kind of a presentation to the firm. I think this is somewhere we should go, and then the letter, and then further discussion. So that's my understanding as to how this works, but not really knowing how they find who they're going to go after, because they don't tell me. But that's my general understanding.
Well, and that's where it's a good reminder and a good question that every year, every plan files a Form 5500 with the Department of Labor, and that is public information. So they scan it to make sure that you didn't accidentally put in somebody's social security number or something. But after that, it's posted to the DOL's website, a number of other searchable resources. So that's where they're able to glean a lot of information about your plan before they even have to find a person. And then that's where they can look at who's a target, again, looking at that. Amanda, if there are no other questions, I think that segues next to, our next question of who are these defendants that are being targeted, and who are the plaintiffs going after? Is there a rhyme or a reason? Is there more?
No. I mean, there's a little bit. Well, not completely, but so this slide is a very small representation of the number of or the types and size of companies who are being sued for this. But it's a nice representation to show different sizes. And what I like the most about this slide is it has Amy's Kitchen, and then it has Microsoft. Amy's Kitchen has a $100 million plan, and they are recently sued. That's a very small plan. Microsoft's has got to be in the billions. So you really can see the range there of what's, who's being targeted. It's not very clear. There's no real rhyme or reason to it. And though plans of the small size like Amy's are being sued, they still make up the smallest percentages, right? The bigger fish is definitely a $1 billion plan that has lots of participants. That's where plaintiffs' attorneys want to go. That's how they're going to get bigger settlements. So they don't necessarily want an Amy's, and every time they go after an Amy's type of size, I'm surprised. But there are definitely some smaller plaintiffs shops who are trying to get into the business, want a little bit of the action. And so I think that's why they're going after these smaller plans. And then I read a little bit about, can we say that any industry is being targeted? No. So the medical industry does make up the largest percentage, but it's still not a majority. And then the medical industry, right, covers tons of hospitals, could be a medical school. So it's a very broad category. So it's very much, there's no rhyme or reason necessarily, I think, to what we're seeing right now.
And let me interject there. I think you make a really important point, Jen, about this. That people, to correct me if I'm wrong, but the plaintiff's bar is really focusing on this. It's a financial exercise from their perspective. What's going to be most lucrative for them in terms of a lawsuit? It doesn't mean that the small companies and organizations are immune from these sorts of lawsuits, but at this stage, to target the big billion-dollar plans means that they're more likely to, if they succeed, secure big settlements that allow them to fund future lawsuits. And so, people, I think, sometimes mistakenly like to believe that this is all about, some plaintiff's attorney wearing a white hat trying to, make the world safe for fiduciary responsibility, when in fact it's really being driven by these financial considerations behind the scene.
Yeah, I mean, I'm a defense attorney, so obviously I believe that about all plaintiffs' attorneys. But yeah, I do. It does feel that way. I mean, it's definitely. I mean, this is how they make their money. This is how an associate finds one of these cases. They bring it to the firm. They decide to sue, and if they make big on that, that makes them partner. I mean, they're definitely not disinterested people when they're bringing these cases.
Have you also seen, I mean, again, and I know, Jennifer, this might be a little outside of what you've seen, but, tangentially, the Department of Labor and IRS have increased the number of investigators that they're having on their staff to go after these plans. And what I've heard through different discussions with different attorneys is that they're kind of following the plaintiff attorneys' playbooks in some respects. And maybe that's outside of your purview, but is that a permutation you've heard anything about, or is that not something you can comment on?
I've only seen it a little bit, but the issues do overlap. And then, if the DOL is investigating an issue, it's definitely going to come out when the plaintiff's attorney, when they start discovery. So it's definitely something I've seen, and it's definitely something that can aggravate the case, unfortunately. So it's not great when you're from the defense. From my perspective, when I see that there's also a DOL investigation on one of the issues, it complicates matters. It doesn't mean that my client did anything wrong. It just complicates things.
Yeah, and that's where we've seen, again, these are obviously mostly billion-dollar plus plans. But, again, as there is some targetings down to smaller plans, and then, again, some of the issues and fiduciary breaches that the plaintiffs are arguing on are also things the DOL will take a look at on smaller plans, as we've had some experience with that. So I think one of the things that we always try to encourage groups is, this is where the case law and kind of processes get set, is at these billion-dollar plans, but then they trickle down the expectations to much smaller organizations. So now that we've kind of talked about the risks, what, Jennifer, would you look at as kind of those fiduciary practices that plan sponsors and fiduciaries should take, to make their plan, more of a defensible plan, or a porcupine that the law firms don't want to try to go after?
So my number one thing is to document your decisions. And though meeting minutes are not required by ERISA, it seems as if even at trial, I mean, even when I was at trial and the witness was sitting there, the judge still was interested in what was actually written in the minutes. It's very frustrating, I find, but you do have to show what you're doing, what are you talking about, how much time you even spent on it is good, more time is better, particularly if you're not meeting frequently. And you have to remember too, the statute of limitations for one of these cases is 6 years. And then sometimes discovery goes outside 6 years. So maybe you're talking like 8 years, and you're not going to remember what you said at a meeting 6 years ago. But what you said at that meeting might actually be really important. So that's why from when I'm putting together defense, it's really, I find it's been helpful to have more information, not less. It could be even bullet points, but just really showing what you did, showing your homework is really important. And then,
do you ever cringe, Jen? I'm speaking out from the standpoint of someone who is often asked by a client to review their meeting minutes to make sure, even though I'm not a litigator, but from my perspective, we're not saying something that might put them in bad stead years down the road. Do you typically see more in the way of minutes, or less, and wish you had more, or too much, or is it all over the
I've
map?
seen all the spectrum, all over the spectrum. I haven't seen too much yet. Like, I haven't seen something that made me cringe. Like, why did you write that down? Right? Usually, whatever, if there's really that kind of point, someone else is telling you not to write it down, like you, Eric. But the hardest thing to deal with in a case is our minutes that are one page. Like, simply saying, we discussed all the investment options. Okay, that's not very helpful necessarily, right? So we can have those general statements, but then break it down a little bit. Yeah, it's much easier from a defense perspective if I have more information written down than less.
Thanks.
Yeah. Similarly, the judges want to make sure that you've kicked the tires. So this is very close to the minutes, right? Because then you'll show that you've kicked the tires in the minutes. And you want to make sure that people are actively participating, that your members actively participate, that they ask questions, that they, push their investment advisor around a little bit. You want to make sure that you can say either in your minutes, or that you can say that you didn't just rubber stamp everything one of your advisors said to do, right? You want to show that if you did what they wanted, you had a reason, you asked questions. And if you didn't do what they wanted, which is also fine, just make sure you explain why you didn't do it. Another thing I think maybe we're not all thinking about, but I always think about from a defense perspective, is who's actually on your committee. And oftentimes, right, it's in a charter somewhere where it's just the title, you're just concerned about the title, like whoever has that title will be participating. But you want to make sure that the people who are on your committee are actually able to participate, right? Some people are super busy, they can't make meetings, or they can't attend, the entire meeting or whatever. And you want to make sure you've got a committee who's active, taking it seriously, and are able to participate. And then, of course, you want to make sure the right right people are there. And of course, investment expertise is really important. And so that's why I lead into investment training there. So obviously not everyone on your committee is going to be know what a Sharpe ratio is, or whatever metric is being shown to you, right? And so if you don't know what that is, how can you actively ask questions about it? So maybe your head of HR, is on your committee for a very good reason. They know the people, they know the benefits, they know what the people want, what your employees want. But they might not, maybe they do, but they might not know what a Sharpe ratio is. So I think it's important to make sure that you've educated the people on the committee so that they can ask the right questions at your meetings. And then this one, you guys everyone knows about RFPs. You should do them at regular intervals, because right now in a complaint, all plaintiff has to say is you didn't do an RFP, and you get passed a motion to dismiss, which is really frustrating. And so I don't think there has to be an RFP for, let's say, your record keeper every 3 to 5 years, but consider doing it within remember your statute of limitations is 6 years. So it'd be nice to see one within some time that period. If you don't do one, make sure you document why you don't do one. And then, it's interesting. One thing that I haven't seen yet, but might be an interesting thing to do, is if you do an RFP and you've had an outcome and you've chosen, you remain with your record keeper, or you pick a new one, maybe tell your participants about it so that they know and they can't claim ignorance when they write the complaint with their attorney about how you didn't do one when you actually did do one. So let's see. Two more things. Venue. This is interesting. You can put choose where you would want to be sued in your plan document. It doesn't always hold up in the case law, but we did have a really good situation where a plaintiff's attorney only wanted to sue their plan sponsors in Florida, and the plan had a choice of venue for Missouri, so we moved it to Missouri, and then the case got dismissed because they didn't want to litigate in Missouri. So, maybe that was just a good win for me, but it is something you might want to think about as well. And then lastly, and then I'll stop talking and let other people talk. Preemptive litigation risk assessment. I have done this for a few clients. And basically it's just to, you give me your committee minutes, give me your plan documents. We talk a little bit maybe with some of the major players on the committee, and we think about, from a litigation perspective, are there any things we need to be thinking about in your process? Anything we can do better? Anything we're doing really well? And then, it gives you a bit of comfort that, yeah, I've got some things going well here. And then you might know, okay, listen, this is where we need to do better. Maybe we need to do that RFP or whatever it's going to be. And yeah, questions? Or anyone else have a comment?
Amanda, do you have any questions from the
I do. So yeah, someone asked, who will defend an employer when they're sued?
So me, but
That's what I thought.
No,
it might be useful to talk about the relation to there, Jen, between insurance coverage and selection of attorney and all that.
Sure. So you're going to want to find, there are a handful of attorneys like myself at firms who specialize in this type of litigation. If you get sued, I promise you a handful of those people I'm talking about will reach out directly to you and and you'll know. Because we're watching the dockets and we will look to see, if one of our clients gets sued, and I'm sure, someone will do that for you as well. And then most of us also have really good working relationships with the insurers. And so that helps as well, right? Because then we work out rates with the insurers. You don't have to worry about those types of things. Even if you have a high deductible, oftentimes my bills go through the insurer, which is another thing you don't have to think about. They're yelling at me if I'm doing something too much, or my team is, you don't have to think about it as much. So that's usually how it begins. And then if someone doesn't reach out to you, or you don't have an ERISA litigator or a relationship with someone like me, oftentimes your insurer will have some ideas about who would be good for you as well.
So there was a follow-up question. Sorry to interrupt, but there was a follow-up question to this one, and it said, is it the employer's ERISA carrier or general liability carrier?
In my experience, it's been the ERISA fiduciary carrier, right, John and Eric? Do you have anything to add?
That's been our, and that was one of the things I was thinking too, as Heffernan has a large insurance brokerage, property casualty broker arm, we've seen a lot more requests from our clients to document in the application for directors and officers insurance and fiduciary liability insurance that you've done this. So I've filled out, for a number of my clients, attestations of all that they've done, to help them. And obviously they're the ones submitting it to their insurance carriers. And one of those questions is, have you been contacted by, the number that you read off earlier that I'm not going to remember because that's not part of my world, but it really was. It was asking, when was the last time you had more than one RFP, and when was there fiduciary training for your committee? And it really was documentation is what we're seeing, because they were asking for not just an attestation from some of the clients, but also documentation that they had done it.
Well, and at the risk of sounding somewhat self-serving here, but there's no way to sort of avoid that. If you're engaging in these, what Jen, you've aptly referred to as sound fiduciary practices, again, you're not going to be conducting a preemptive litigation risk assessment every year, but if you're routinely talking to your advisors about these issues and you're engaging in this sort of thing, in the unlikely event that you are sued, you've already got those relationships built. You know, Jen understands how your committee meetings work, or your advisor understands how your meetings work. Unfortunately, it'll be sort of an organic step next. It's, you know, who's going to defend you? Well, it's going to be obvious. It's the people you've been working with all along who understand your plan. Hopefully you're not flat-footed. And if you haven't built those relationships out, maybe add that to your to-do list, you know, in the coming months, that you really want to just, you know, what is that? An ounce of prevention is worth a pound of cure. You know, the hope is you're never going to be sued, and the numbers would, you know, bear that out. But by the same token, if you have, you know, a whole team of advisors that are otherwise familiar with your plan, if it came to that, you would be all set, and you would work with your insurance carrier to say, I would like X to represent me. And typically, if they're a seasoned ERISA litigator like a Jen Squillario, the insurance carrier is going to say, okay, of course, we'll work with you.
So it sounds like, Jen, if I'm hearing, you know, it's really giving you the tools in terms of these clients working with their advisors, working with all their partners to make sure that they have good fiduciary processes or sound fiduciary processes around all these different pieces is the best defense. You know, obviously nothing is going to make you perfect, but it's also kind of going to make it look like you've scared off the you know, ERISA attorneys that are wanting to go through this, because they get paid relatively handsomely if they win a case or a case settles. Is that a fair statement? So they've got a large incentive to continue these cases and not waste their times on, you know, groups that have done good processes and looking to find ones that have found mistakes. So, you know, this is helpful in terms of looking at it. You know, do you have you know, you had mentioned a few documents that are in there. You know, one of the things that we always hear is, you know, it's like you said, whether it's a charter or an investment policy statement or fiduciary training, it's always better to have a document, but making sure you follow those documented processes, if you have it, is also a solid step. Is it, you know, would you say that it's fair to have that having some of these documents and then unintentionally not following them is almost more dangerous than having them?
Yes, if particularly the one that hits home particularly is the investment policy statement. What plaintiffs are doing now is they're looking at your, let's say you have your TDFs, and they can figure out that you monitored your TDFs against, I don't know, index A.
Your target date fund, right? Just so people know.
Target date fund, and you're monitoring it against benchmark index A. I'm making that up for our discussion. But then the plaintiffs get a hold of your investment policy statement, and it says that your target date funds were going to be measured against index B. So now they add that to their complaint, and that's been something that's helped plaintiffs get past the first stage of litigation, the motion to dismiss stage. So yeah, not following it is worse than not having one. There aren't, you know, I have a case right now where there is no investment policy statement. But as the case evolved, plaintiffs kind of let that go because it's not really going to get them anywhere. So yeah, following it when you have it is important.
What would you say, Jennifer, are some things as plan sponsors are reviewing their plan with their, you know, fiduciary advisors, or they're reviewing it with their committee or whoever's helping them, you know, if they're going through their plans, what would you say, you know, and I heard one of them is an RFP within 6 years is a good example. What are some other things that, you know, from a positive plan health and defensible standpoint, would you say are things that if plan sponsors look at their plan and they see see certain things, what should they be on the watch out for as they're reviewing their plan? Which probably a few of them will be doing in about 20 minutes when we're done.
Do you have more than one record keeper? If so, why? That's going to be a question. And there are some really good reasons out there for why you would have 2 record keepers. But having 2 is going to be something that puts plaintiffs, you know, they're going to be like, great, I'm going to use this in my complaint. This is going to be great. I'm going to get past motion to dismiss. So that's the first thing. Do any of your funds have long-term underperformance compared to its benchmark, right? So a fund could outperform every other fund in your plan, but it could still underperform its benchmark. Now you would say, that's ridiculous. It's doing so well. Why would I ever take it out? But all the plaintiffs are going to say is, but it's underperforming its benchmark. So think about, is it the right bench? You know, you talk to your investment advisor and figure out why that's the case, and see what you can do about it. Because you don't want to remove your best performing fund, right? It's ridiculous, and it's ridiculous that plaintiffs' attorneys can get anywhere by saying, well, it underperformed its benchmark, so it wasn't doing what you said it would do. But that's the reality of the world we live in.
So it's a lot about making sure you're lining up your processes and following those evaluation procedures.
Mm-hmm.
Is there any thought you have on fees when it comes to 401k plans? Obviously, when the fees are, to my understanding, when the fees are paid by the plan sponsor, that removes a fiduciary issue under ERISA. Is that a fair statement?
Oh, I haven't had one that was like that yet. But so I would imagine if it's not being played out of the plan, then yes, you're in a much better position. Just make sure that the participants really understand that, though, that's how it's working. But yeah, I would assume that would be a good thing.
So when it comes to monitoring fees that are paid out of the plan assets, is the goal to lowest is best, or what is the process for evaluating service?
Yeah. Well, that's what plaintiffs say, right? They say all plans of the same size get the same services, so you just got to find the cheapest. Well, we know that in reality that is not true, right? There are some main things that, for instance, a record keeper does, right? But you might have some particular things that you want, and that your participants want, and your employees and what they are going to require, and so that may cost more. So it's okay if it costs more, just know why it costs more. And unfortunately, when they bring a complaint, they're using those Form 5500s and they're saying this is how much you pay for record keeping. But oftentimes those forms they're not meant to do that. They're not telling the participant that type of information. So that's something we're really dealing with right now in the case law. Is trying to get it where plaintiffs can't just take whatever numbers are in your Form 5500 and say, hey, you pay a lot for record keeping, because it's just not an accurate presentation for plan sponsors.
Yeah, those Form 5500s have a lot of information, but it doesn't always tie out in the way that the plan sponsors want to manipulate the numbers. Amanda, have any other questions come in?
Yes, we had one that said, how do I fix past mistakes before I get sued?
That's a good question. I mean, you can improve, right? A committee can improve its process. You're always improving your process. So if it's just a process thing, just make sure you're on the right path going forward, right? I mean, I see that particularly when these cases started to come out. I mean, there are some really big companies who didn't have a committee, right? Didn't have one until they got sued. Okay, well then they had one, and let's talk about, what the process is now. So I don't think all hope is lost. Just try to do the right thing going forward, or get your process shored up. What do you think, Eric?
It's another really valuable point. This is you're maintaining and you're building and maintaining your committee on shifting stands here. These lawsuits have been going on now for almost 18, 19 years. And what was a sound fiduciary practice in 2006 may not be sound today. I might put you on the spot, Jen, and see. I mean, you've seen a lot change over the years. I certainly have in counseling committees, but I think you not only have to always do your best, like you say, but you have to be aware of what's going on in the litigation world and kind of adjust your thinking. I think in the beginning we used to say, if your committee meets 3 times a year, that's okay, 3 or 4 times a year, and that's still the case. But how we used to draft minutes, for instance, we used to draft specific wording. We used to draft very specific investment policy statements. We've tried to soften the language where we can, so we don't have absolute language. We don't want people to be hung out to dry on words. You know, it all means something, and you try to look at it through the lens of what might this look like 6 years from now if Jen Squillario is looking at it and trying to defend us. So I just think you have to be contextually aware of, you know, where we are today. And maybe that's a question for you, Jen. I mean, you know, they started off, like you said, with the biggest companies being sued. And then there was a time where we saw some copycats, and then they went after all the universities. And then there's been kind of a lull. Where are we now? What inning are we in? And is there a retrenchment? Are we favoring plaintiffs?
Yeah.
Are we favoring companies?
So the first quarter was slow for filings. I don't think it was because plaintiffs are not doing this anymore. I just think that they're very busy. I think something like 50% of the cases they filed, don't quote me on this, but something like last 5 years, still exist today. And I'm preparing for trial for one that was started in 2016. So they're busy, and there's only so much they can handle at a time. And I happen to know that a number of them have, there's another trial Yale started today. So there's another, you know, some of the defendants are pushing them farther. So, right, if I push a plaintiff's attorney to go to trial, he can't really do his other work. And so I think a lot of that is what's going on right now. And at least this second quarter has been super busy for everyone. And that being said, the case law we thought was going more defense side, but then, you know, it's not clear. I mean, if I was a plaintiff, I can still find a way to bring a case, you know, with the case law.
Well, and there again, you sort of touched on the economics, and John, I apologize for keep interrupting, but again, for people to understand, if you're a plaintiff's firm that has a bunch of these cases, remember, you're working largely on a contingency. So I guess, Jen, what you're paying your team of employees to kind of do this work on the hope that you're going to, you know, ring the bell on a couple of these cases, but you know, unless you're a Schlichter who's won a string of these cases and sort of has the money to keep funding your team, it's an expensive proposition to mount a class action case, isn't it? I would imagine.
Yeah. Yes, it is. Yeah, at least that's what they claim when they claim they spent X amount of dollars. Yes, they're trying to settle. Yes, they must spend a lot of time and a lot of money on these. Yeah. Yeah.
Sorry, John, I'll turn it back to you.
No, and that gets to the point. Like if it's a lot of time and a lot of money, they're gonna look at pretty quickly at, you know, those discoveries, going through that information and what they're requesting from you. And if, you know, they see it sounds like, you know, you've done a benchmark, you've negotiated fees, you've got a documented process, probably, you know, your best defense on getting glossed over for saying this is going to be more time intensive. Let's find somebody who hasn't done anything. And go for them. And I think that's where your earlier comment on, you know, the question of what if we haven't done this, you know, you can't fix the past necessarily, but you can make sure, you know, starting today, you get on a good foot and you start doing the right things and begin those processes. Again, I think, you know, Jennifer, you mentioned doing the preemptive litigation risk. If someone's really concerned that, you know, oh, we never have had a committee, we've never looked at all of our investments, they're all proprietary to our record keeper, you know, it might be a good reason to reach out to you and just see how likely you are. Again, you know, to Eric's point, if you're a $5 million plan, you know, you'll want to fix it to help your employees have a better plan, but your likelihood of getting sued at a $5 million plan is low. Right. Because the attorneys just can't make enough on poorly, you know, on that for work.
Mm-hmm.
Well, and I will say, if there's one thing I've learned from Jen, if there's a single takeaway anybody could get from this, it's to banish from your vernacular the notion of best practices. Jen has taught me again and again, you know, this is a spectrum, right? You try to do better, but try not to refer to best practices. And I'll let you sort of tackle that, Jen.
Yeah. This is purely from just a defense attorney's perspective. But, you know, when you show me a document that says your investment advisor said these were your best practices, and then you tell me you didn't follow them, and then I say, great, because at deposition, now you're going to be asked why, if it was best, you didn't do it. And there's very good reasons why you didn't do it, but it's just easier this is just if I was writing the world of committees and I was sitting in there, I would say, let's use sound fiduciary practices instead of best practices. But yeah, that's just me working up a case and trying to do my best for my clients.
And have you seen, Jennifer, just I know we got a few more minutes, and so I just want to go through it. What are what are the record keepers kind of statuses in all of these lawsuits?
Yeah.
You know, obviously everybody hires a record keeper. I mean, you may have a consultant, an advisor, you know, that part could vary, but everybody has a record keeper. What is their kind of role or process been in these lawsuits? Because, you know, like you said, it hasn't been one record keeper, it hasn't been one specific, but where's the range kind of been on those relationships?
Yeah, so right, there are a number of different record keepers, and some you see continually more frequently maybe than others, but they don't ordinarily get sued because they're not ordinarily a fiduciary. That being said, they are usually, because they're so familiar with these cases now, they're very helpful. And if you get sued, they're more likely already have a way of getting you everything. Like, you're going to be asked for certain documents from them. They're prepared. They know that they're going to be there to support you. So it's not like they're like, oh, hands washed, you know, you got sued. But my experience has never been that. They're supportive, and they want you to come out on top as well on these cases.
Yeah, and I think that was the distinction that sometimes was lost previously, and it's becoming more apparent, is the record keeper will be your partner, but they're not going to be a defendant.
Right, correct.
So they obviously don't want their clients losing lawsuits, but they're not going to be losing the lawsuit just for any of those, you know, Microsoft or whatever. I'm sure the ERISA attorneys would love to get them on the defense as well, because they have deep pockets.
Sure.
Amanda, do we have any other questions?
None at the moment.
Okay, great. So again, getting to that same point, you know, you brought up a good reminder, you know, for those that do work with fiduciary advisors, whether it's a 316, a 338, or a 321, what would you say to your clients just as a reminder about those relationships?
Right. So regardless of what type you have, you still have to monitor them and make sure you understand what they're doing. With a 338, where they take on more of the responsibility, there might be some good case law evolving about that, you know, that you don't have to monitor them in the same way you would a different, an investment advisor who has less fiduciary, you've delegated less fiduciary responsibility to them. But from a defense perspective, from my perspective, I would want you to continue to monitor your investment advisor regardless of the amount of fiduciary responsibility they have. That just makes my job easier. It's never going to be, at this point right now, it's not a forget it, it's not a set it and forget it type of situation. And I do know a 338 advisor who has been sued with the plan sponsor with their many plan sponsors on numerous occasions. And the plan sponsor doesn't always get out of the litigation just because they had a 338. So it's definitely something to think about.
Yeah,
and
that's
I
where
would add that to, I was going to say, John, I would add that to your agenda. I mean, it's they're being paid out of plan assets most likely. So it is part of your fiduciary responsibility. And once a year or once every couple of years, you should be acknowledging that and saying, we've considered the fees we're paying and, benchmark them and determine them to be reasonable. And, we're making sure, like Jen said, that they're doing what we hired them to do. That's better than not having anything at all in your minutes.
Yeah, and that's where, again, as Heffernan can act as a 338 or a 321, we don't take on the 16 responsibility. We do always encourage our clients to understand that they are still the fiduciary at the ultimate level to the plan, because they've made the decisions of who to hire and outsource things to. I always make the joke, if you hired Bernie Madoff to be your 338, that has not protected you from issues. So, making sure you meet with your fiduciary advisors, making sure they're doing what they're doing is important. And again, that's where outsourcing is wonderful, but I think there sometimes is a misconception about how much has been outsourced.
Mm-hmm.
Wonderful. Amanda, do we have any other questions? I know we have a few minutes left, and we could give everybody a few minutes back of their day, but don't want to cut anybody off if there are still questions.
All right, I don't have any at the moment either, so I think we're clear to go.
Wonderful.
But maybe we can check in at the end.
Eric or Jennifer, final thoughts? No gold nuggets to hand out at the very end for the people who made it all the way through.
Again, from an ERISA geek perspective and just an advisor perspective, again, I hope people walk away from this and sort of appreciate it. I just find it fascinating, the mechanics of how these lawsuits are commenced and how they pertain, and to view it from the lens of somebody who's lived it. I think really makes me think about, again, how would I refine advising committees? And from a committee perspective, I would hope that committee members and plan sponsors would think about, yeah, we're probably doing, most things right, but I think Jen, you said it best, there's always room for improvement. So it's not a bad idea to go back and kick those tires and see where you can refine your process.
Correct. Yeah. Well, thank you. This was fun.
Yes, thank you, Amanda, and thank you everybody for attending. We hope you found something valuable in the hour of time, and we didn't hopefully scare anybody off and wants to end sending a retirement plan for their employees. But we just want to make sure you have some resources. And again, if there are questions, please don't hesitate to reach out to us. We'll all be able to answer any questions, and appreciate everybody's time.
Awesome. Well, thank you, everybody,
Thank you.
for attending today's webinar. We'll send information by email with instructions on how to access a copy of the presentation on our website. Thank you to the presenters for their time and expertise today. We hope all the attendees found today's webinar to be a valuable use of time. We'd love for you to join us on May 30th for our active shooter or armed assailant response training for the DHS Run, Hide, Fight Protocol webinar. And have a safe day, everybody. Thank you.
Take care. Bye-bye.